So Judge Benitez has already taken the reins in the Miller v. Bonta California assault weapons ban case and has set a hearing to take place next Monday. So let's talk about this. But real quick before we jump to this video, if you believe California's ban on so-called assault weapons is unconstitutional, go ahead and hit that like button and subscribe. Also want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense and liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the detail section. So like I said in the intro, Judge Benitez, or Saint Benitez as he's known in California, is taking complete control of the Miller v. Bonta California assault weapons ban case. Notice hit a couple days ago that he has already set a hearing for this case to take place, which will take place next Monday. This comes on the heels of the 9th Circuit remanding the case back down to him just a couple weeks ago and remanding it back down to him for reconsideration in light of Bruin and that Supreme Court decision. That was an effort by the 9th Circuit to punt this case once again and to try to stall this case out for as long as possible. However, Judge Benitez, being who he is and I guess what he believes, is wasting no time and has already ordered the parties in this case to file their supplemental briefs on this issue for him to reconsider, and has also set a first hearing to take place next Monday, which is just days after, or actually a day after, the briefs are actually due. Now, for those not aware, Miller v. Bonta is a challenge to the state of California's ban on so-called assault weapons. Under California Penal Code Section 30515, the state bans various types of firearms based on their characteristics. For example, a semi-automatic centerfire rifle with a detachable magazine cannot have a flash hider, a collapsible stock, or a forward vertical grip. If it does, then the state of California defines that as a so-called assault weapon, and you are prohibited from possessing it unless you fell under some of the registry requirements that happened a while ago. The Miller case was originally heard in the Southern District of California before Roger T. Benitez. In the original review of the case, Judge Benitez found that this case was an average case about average guns used in average ways for average purposes. In reaching his decision, Judge Benitez used a standard review that was just reaffirmed by the Supreme Court in Bruin. He looked at the text of the Second Amendment and the history of our nation to determine if the state's ban on these types of firearms is indeed constitutional. He determined that the state of California's ban is not in line with the text or history of the Second Amendment, and therefore it was invalid. In fact, in reaching his original decision, he stated, "A ban on modern rifles has no historical pedigree. Prior to the 1990s, there was no national history of banning weapons because they were equipped with furniture like pistol grips, collapsible stocks, flash hiders, flare launchers, or barrel shrouds. In fact, prior to California's 1989 ban, so-called assault weapons were lawfully manufactured, acquired, and possessed throughout the entire United States. Because the ban was not in line with the history of the Second Amendment, he found that it was unconstitutional." Well, of course, the state of California did appeal, and they were also granted a stay by the 9th Circuit. Then the Miller case was put on hold at the 9th Circuit level because of a backlog of Second Amendment cases that were waiting for the Supreme Court to rule in the Bruin case. However, recently the Supreme Court did issue their ruling in Bruin, which struck down the 9th Circuit's use of the two-step approach, which is a type of analysis that the 9th Circuit and liberal courts have used to uphold various violations on the Second Amendment. And also the Supreme Court affirmed or reaffirmed that text as informed by history and tradition is the correct type of analysis when you look at the Second Amendment and these types of restrictions. In reaction to all this, FPC through outside counsel filed a motion to lift the 9th Circuit's stay and to also fast-track review of this case through the 9th Circuit. Well, the state of California opposed, of course, lifting that stay, and also they pushed the 9th Circuit to vacate the Judge Benitez original ruling and to remand the case back down to him for reconsideration in light of Bruin. Essentially, the state of California's only tactic was to try to get this case remanded back down to the judge that has already ruled against them on this issue. This really shows how weak the Bruin decision made these types of bans like the state of California has. Typically, the state of California has no issue letting a Second Amendment case run its way through the 9th Circuit because of the 9th Circuit's use of the two-step approach that they often lean on, and simply because the 9th Circuit would always defer to the public interest that the state of California would present. But all of that is no longer valid, so the state of California no longer feels confident that the 9th Circuit could rule in their favor. Then a couple weeks ago, we got an order from the 9th Circuit that they were going to indeed vacate Judge Benitez's prior ruling and remand the case back down to him for reconsideration of the case in light of Bruin. Now that this case is back in the hands of Judge Benitez, he requested that the parties file additional briefs on the impact of Bruin. And those briefs are due on the 28th of this month. So technically on Sunday, but they actually have to file them, I believe, by the end of the week because you can't file them on the weekend. So we will see those start to roll out here in just a couple days. But after doing that, he also set a hearing to take place. The docket entry reads, appeal mandate hearing set for 8/29 at 9:30 a.m. in courtroom 5A before Roger T. Benitez. Now, I know there's been some confusion going around about what will actually happen at this hearing. Personally, when I saw the notice of the hearing, to me, it was pretty vague about what is actually going to happen and what are going to be the implications of that hearing. I've seen some people speculate online that this is going to be a whole shebang hearing, but my impression was that this is likely going to simply be some procedural cleanup and just kind of deciding how stuff is going to go moving forward. But it could also be some sort of arguments that maybe happen at this hearing in regards to those briefs which are due. So I decided to reach out to someone who is intimately familiar with the case, and that is John Dillon, who is actually one of the attorneys on record for this case and is part of the actual litigation of this case. And I figured who better to ask maybe what they are expecting out of this hearing, which is taking place Monday, than one of the actual attorneys for this case. So here's the official statement from John Dillon. He stated, Judge Benitez scheduled a hearing on Monday, August 28th, in which both parties are expected to appear. The hearing could present both procedural and substantive issues related to the next steps in this litigation. We are looking forward to hearing what the court says and moving forward in this case. So what does that actually mean, kind of removing that out of the lawyer speak? I know I'm a lawyer, but for you guys who don't read between the lines, what does that actually mean? Well, the hearing Judge Benitez set is a little bit vague. It's up in the air right now if the hearing will simply just be procedural cleanup or if there will be something more substantive and some sort of substantive arguments that will actually take place at that hearing. Really, it depends on what Judge Benitez wants to come out of that hearing. He could use the hearing to limit any new evidence to historical evidence that is required under Bruin, and he could also use the hearing to accept all prior evidence that maybe was presented at the original trial. So he could use this to kind of just limit the scope of this case to kind of dictate what's going to happen going forward in this case, but he could also do more in this hearing if he wanted. Really, what you should expect, at least from this hearing, is Benitez taking the reins in the case and telling everybody, all the parties, how this is going to go from here. However, because of the nature of this case, there could be something with larger implications that comes out of the hearing, which bears directly on the enforcement of the ban on so-called assault weapons. So for everyone in the state of California, for all the gun owners in the state of California, now is the time to stay tuned to these issues. Because as a lot of you know, things can change really fast. Many of you know how crazy it was the first Freedom Week in regards to magazines, and then we had the Ammo Day issue, and that was even faster. So just be aware some things could change sooner rather than later. Things could change really fast, and we will be waiting to see what comes out of the Monday hearing. Hopefully it's maybe a little bit more something substantive that maybe has some impacts and benefits us. But again, I would expect maybe just some procedural stuff, but we don't have a whole lot of clarity of what Benitez actually expects to do during that hearing. I know some of you may ask if you can actually watch that live. The answer to that is no, in my belief. I don't think you can. I've never seen that. Live hearings usually only take place for circuit court oral arguments and also for Supreme Court oral arguments. So that's not an option I believe you have. If I'm wrong, someone correct me or show me a link if it pops up, I guess on Monday, so I can share it with everybody. So in my opinion, that's not an option, but I would fully expect that after the hearing, it takes place at 9:30, we will get some sort of news. And if we don't, I will try to get some information for you all so I can update you guys. So we all knew Judge Benitez took this issue and this case very serious. I think the speed at which he is moving this case forward only further proves how important he actually knows this case is. So hopefully that gave you guys some better insight of what's actually happening in this Miller v. Bonta ban on so-called assault weapons. If we get any more information, I will let you all know. If you have any questions, go ahead and comment down below and I'll try to answer best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algorit's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget to stay with Built by Armed Scholars, and this nation will be maintained by Armed Scholars.